Hello, great warriors for liberty, peace, justice, decency, honour and morality and ethics. Glenn Floyd calling you again from our little country town, Maldon in Victoria, Australia, and also from our little wonderful art shop of our own paintings and books called the Painter and the Writer Gallery in Maldon. Calling you with some very wonderful news following on from the recent video that I made that shows we now have at law strong irrefutable evidence that that the sacking threat made by worldwide and Australian employers automatically prohibits any injections taking place by law. Now, I put a disclaimer out right now. I am not a lawyer, do not give legal advice. This is only for educational purposes only. If you need or require legal advice, you must consult a lawyer. This is not legal advice. I'm doing my PhD in law, which is going to take a damn long time. Nonetheless, I'm collecting evidence around the fact, in my view, that there is now irrefutable evidence that the employer sacking threat for injections for COVID toxic Fauci Frankenstein COVID cyanide poison was an unlawful directive. And I'll give you the information now, and particularly the latest information which came to us as recently as the 31st of March, only a few days ago. Now, what is the law? And by the way, this is my interpretation of what is the law, but it is not legal advice. These statements are made and taken from the government websites. The immunisation guideline, immunisation guideline criterion 2, requires valid consent to be given from any person to be injected. Now, valid consent means under criterion 2 definition of the immunisation guidelines that valid consent must be given. Valid consent is defined by them that this consent must be given voluntary in the absence of undue pressure. Guess what in a sacking threat for non-injection is by an employer? An employer sacking threat is pressure. This now leads on to the Fair Work Commission cases. I ran 80 of them over the last few years, and in particular, I was able to get Deputy President Bernadette O'Neill to legally rule on page 13, paragraph 56 in the Jetstar case that I ran, that the direction to be injected did involve significant pressure. This is a monumental ruling, because we now do not have to prove at law or fact that there was pressure placed on these people, poor people, to be injected. And I've seen suicides, family breakups, mortgages, homes lost, horror in the work that I've done, and I work pro bono, will not take any money at all for assisting people who are crushed by the legal system. Now, the most recent 31st of March statement I've got and declaration is from the Victorian Health Department, which formally declared to me in an email that immunisation that are authorised to administer approved vaccines under Secretary approvals are required to comply. These injecting practitioners are required to comply. That means legally binding with the current edition of the Australian Immunisation Handbook. This is a formal government guidelines criterion, valid consent declaration of legally binding. So we don't have to prove that pressure was applied. Deputy President Bernadette O'Neill has ruled it was applied. Now, of course, she also made the statement that the pressure was not unlawful. We don't care. Bernadette O'Neill, Deputy President. We never argued that the pressure was unlawful. An employer has got authority to make all sorts of pressure applications in the employment contract because they own the contract. They can ask you to work overtime, not work overtime, take leave, not take leave, lower your bonus, all sorts of things. Nonetheless, even though they've got the authority to make these declarations of pressure on you to do things, and that it is not unlawful for them to put pressure on, as soon as they put pressure on, because of the immunisation guideline criterion 2, which declares there must be no pressure or the injecting practitioner cannot proceed by law. The Victorian government has now declared to us in this email back to me in writing that immunisers that are authorised to administer approved vaccines under the secretary approvals, that means delegated law under the ministerial delegations of guidelines, regulations and edicts, are all law as ministerial delegated law. So this is the formal government edict now. So we've got the Mental Health Commission, sorry, the Fair Work Commission Deputy President Bernadette O'Neill declaring significant pressure was applied. As soon as she did that, that is law that it was applied. We don't have to prove it. And this result now, this declaration from the Victorian Health Department declares the immunisers are required to comply, which says you must, not you should, you must get valid consent, which is defined as consent given with no pressure to be injected, such as a sacking threat. So it is now written in law. We're putting this to a class action we want to develop, whereby we're also going to take a GoFundMe page and get an Australia-wide class action against all employers who have put a sacking threat on people, because in law, with these two rulings of the Deputy President of the Fair Work Commission and the Victorian Government now declaring that not only that the immunisation guidelines do apply, but they must be observed. They're legally binding. Now, I also have a transcript from the Qantas Jetstar King's Counsel named Richard Dalton. And I questioned these people in Qantas with Richard Dalton, King's Counsel, for 6 hours. And I was able to get this King's Counsel, Richard Dalton, to actually make a statement, and I have the audio and transcript of his statement, where he stated by the way, there's a Glenn Floyd template document that we get people to go in, sign informed consent. Then when they've given their informed consent, which merely lets the injecting practitioner know that they've been shown the risks that this filthy rubbish may kill them or harm them, when they sign informed consent, the law shifts over to the injecting practitioner and valid consent must be then given, which means that the injecting practitioner must determine and obtain valid consent, which means the knowledge that they've come in with no pressure whatsoever to be injected, such as a sacking threat. Now, in all these cases we ran, we got the employees to sign the valid consent showing the risks. Then we got the employees who were threatened with sack to give the document to the injecting practitioner, showing them that they're aware of the immunisation guidelines, which says the injecting practitioner cannot inject without valid consent, which is defined as the person must come in without any pressure to be injected, such as a sacking threat. And in all the cases we ran, these people gave this document, the Glenn Floyd template, notifying of the immunisation guideline to the injecting practitioner, and they all refused to inject because they knew the immunisation guideline prohibited them injecting. What does that mean in law? It simply means that once the employer gave a sacking threat, that means that is pressure to be injected. As soon as that sacking threat was put on, they are allowed to give a sacking threat, but as soon as it's put on, it is automatically pressure, and they knew or ought to have known, because ignorance is no defence in law, they should have or ought to have known that the sacking threat automatically prohibits the injecting practitioner from injecting. So because they put the sacking threat on, it automatically prohibits the injecting proceeding. And if any employer gives anyone a directive and then places a barrier in front of the employee to comply with it or carry it out, such as a sacking threat, which stops the third-party injecting practitioner from injecting, that is the employer stopping their own injection, their own directive for the injection being complied with. So once a employer puts in a barrier to their own directive, it is an unlawful directive under the Fair Work Act. Just to show you the two people, the prominent people who are dealing with this matter. On your right, you have King's Counsel Richard Dalton, Jetstar Qantas King's Counsel, whom I questioned with other employees of Qantas Jetstar for about 6 hours. And on your left is Deputy President Bernadette O'Neill, who actually made the declaration in her ruling in the Jetstar case that I ran, made the ruling that significant pressure was placed, which automatically prohibits the injection proceeding. So the employer has stopped their own directive from being carried out. This is an unlawful directive in our view. So I'm getting ready to mobilise a massive Australia-wide class action, whereby we're going to claim, once we get the GoFundMe page funded, we're going to take the matter to lawyers, probably AFL lawyers in Sydney, and we're going to run a massive class action for all those people who were sacked for not taking the Fauci-Frankenstein COVID cyanide, and all those people who took it knowing they'd lose their job, their mortgage and their house and their family if they didn't take it, which is a horror nightmare that's taken place in this country and all countries of the world. And by the way, the immunisation guidelines also apply in most UK-based legal systems. So there we are. You've been shown the people involved. The good news is that we've got this declaration now from the Victorian government, which actually states the immunisation guidelines do apply and the immunisers must comply. It's legally binding for them not to inject if someone comes in under pressure to be injected, such as a sacking threat. I'll sign off now. Thank you for watching. Please send this viral. And I've also come up back from Melbourne yesterday, where I was formally signed in as the member of the House of Representatives candidate for the seat of Nichols in Central Victoria. So I am now the official Trumpet of Patriots Party candidate for the Nichols seat in Victoria, Australia. Thank you. Signing off. This is great news. Please send this viral, because this is, in my view, this is an unassailable fact in law that we have now got the Deputy President of the Fair Work Commission declaring that significant pressure was applied, which stops the injecting practitioner injecting. And we've now got the state government of Victoria declaring that they are obliged, legally obliged to comply with the immunisation guidelines, which says they cannot inject anyone who comes in under any pressure, such as a sacking threat. Thank you. Ciao. Watch this space.